hear and see everything. But otherwise, if you'll just make yourselves dark and silent. I'm going to start adding students into the room now.
Really want you to focus as possible on what those students are doing. They've worked so hard for this moment.
All right, I've just let several additional folks into the room. Hello, everyone. I'm Judge Mitchell. I'm going to check with you individually and just make sure that you can hear and see okay. And so if you'll just give me a thumbs up when I call your name, let's see, or actually I'll need you to talk because I've got a grid view and I can't see you all. So Virginia Lyon.
Here, Your Honor.
Hearing me fine? Great.
Yes, all set.
Okay. Let's see. Parker Hudson.
Here, Your Honor.
Thank you. All right. Emma Nichols.
Here, Your Honor.
Let's see.
Hello.
Hi, Mark. I was just telling the other judges that you're all in the room now. If you're hearing and seeing me well, just let me know.
I see you and hear you well.
Okay, good. If you'll just mute your mic and turn off your video, so all of our judges will be dark and silent for the round, and I'll check in on you, make sure you're back if we take any breaks. Okay?
Okay.
Let me know.
All
if
right,
you're
thanks, Judge.
difficulties. Y'all just let me know. All right, let me add in a few more folks to our room. Okay, Delaney Gold Diamond, are you seeing and hearing me okay?
I am, Your Honor. Can you hear and see me?
Yes, thank you. All right, Enrico Trevisani. I don't think I did very well, Enrico. I'm sorry about that. Can you see and hear me okay?
I can, Your Honor, and you did great.
Okay, thanks. Okay, Emma in Virginia, I've talked to you. Chandler Matz, are you here? Here we go. I'm about to let Chandler in. All right, I just let in Chandler Matz. Can you hear and see me okay? Chandler Matz, are you in the room? Can you hear me?
Yes, I'm here.
All right, very good. And Jack Ayers?
I'm here, Your Honor.
All right. And then Cheyenne Smith? Let's see. Don't have her on yet, okay. Jenna Forster?
Yes, Your Honor. I'm Parker Hudson.
Okay. Oh, okay, Parker. Gotcha. All right. I've got a list with your character names on them, don't I? All right. And then that's all of you. Okay. Good afternoon, everyone. Welcome to the final round. Congratulations on getting here. I'm Judge Mitchell, and I'm going to call the case. I've asked our judges if they'll go dark and silent, and you all just alert me if you're having any technical difficulties, and we'll stop and get those resolved. So we're here for the case of Jordan and Drew Fuller as next friends of Sam Fuller versus Coslo Grocery. Is counsel for the plaintiffs ready?
Yes, Your Honor. Good afternoon. May we make appearances?
Okay.
My name is Enrico Trevisani, and on behalf of the plaintiffs, Jordan and Drew Fuller, will be here in court today. Today, I'm joined by my co-counsel.
Good afternoon, Your Honor. Delaney Gold Diamond for the plaintiff.
And Your Honor, this is the plaintiff in today's case, Mr. Jordan Fuller.
Good afternoon, Your Honor.
Your Honor, once the defense has made their appearances, we do have a few housekeeping matters to attend to.
All right. Is the defendant ready?
Yes, Your Honor, we are. One point, it appears that one of our witnesses might be currently stuck in the waiting room.
Let me check there. Yes, thank you.
Thank you, Your Honor.
Looks like we're all here. Yeah. Okay. Thank you. Go ahead, Ms. Lyon.
Good afternoon, Your Honor. My name is Virginia Lyon, and I'll be here on behalf of the defense, Coslo Grocery, along with my co-counsel, Ms. Emma Nichols.
All right, let's take up any pretrial matters that we have. Mr. Trevisani or plaintiff, proceed.
Yes, Your Honor. First, the plaintiff asks for constructive sidebars. Since in this virtual format, there's no way for us to approach the bench, we would just ask that all objection arguments be heard constructively outside the earshot of the jury.
Those will be constructive, yes.
Your Honor, once an exhibit has been admitted into evidence, would you prefer that we publish it on screen, or would you like us to ask permission each time?
Once the exhibit has been permitted, we may feel free to use it with the jury.
Yes, Your Honor. We also wanted to confirm that Your Honor has received an electronic notebook filled with the exhibits for today's trial.
Yes, I have. Thank you.
And Your Honor, during the pretrial conference with opposing counsel, we've met and we've come to an agreement stipulating the admissibility of 2 more pieces of evidence in addition to the list of exhibits that Your Honor admitted in your pretrial order. Now, those are exhibits 10 and 13.
There is no opposition to those exhibits.
None, Your Honor.
Right, they'll be pre-admitted.
Finally, Your Honor, consistent with the rules of this jurisdiction, we are required to present to Your Honor any demonstratives that we plan on using today. To be clear, we will only be using these demonstratives using exhibits that are entered into evidence, but we're prepared to share our screen to show those demonstratives at this time.
Okay, proceed.
This is our first demonstrative, Your Honor. And here's our second one.
Are there any objections to using these as demonstratives?
No objections, Your Honor, so long as these exhibits come into evidence at some point during trial.
All right.
Your Honor, with that, we have no other housekeeping matters. And once the defense addresses any housekeeping matters, we're ready to move on to substantive issues.
Okay, let me hear from the defense on any housekeeping matters that you have.
Yes, Your Honor, no housekeeping matters from the defense.
All right, then we're ready to proceed. Is that correct? All
Yes,
right.
Your Honor.
Then
Plaintiff is ready.
good. The court will recognize plaintiff's counsel for opening statements. You may proceed.
They hid the danger. It's a Wednesday afternoon, and we can hear the familiar sounds of a grocery store. The creaky carts, the 80s music, the beeps from the checkout lane. At the end of aisle 5 is a sample cart, chocolate-covered protein bars. A little boy, 9 years old, he spots that chocolate from a mile away, tugs on his father's arm. As they walk up to that sample cart, they can see that the employee behind the cart is wearing his green hat and his green apron. They can see the samples set out in plastic cups. But what they can't see is an ingredients list that says peanut flour. No, that's been tucked underneath the sample cart. What they can't see are allergy warning signs still in the manager's desk. 1 hour later, that boy will be in an ambulance without a heartbeat. Members of the jury, I am happy to tell you that Sam Fuller survived that emergency. But the evidence will show that it was no thanks to the defendant. Today, you'll learn that Coslo Grocery knew those samples were dangerous. They knew those samples contained an allergen that could hurt people. But today, the evidence is going to show that they created a policy of hiding those dangers, told their employees, put the product packaging out of view, put the ingredients list out of view, told them even if you know that a sample contains an allergen, don't tell customers. That's why we're here today. Because this defendant hid the danger. Good afternoon. My name is Enrico Trevisani, and along with my co-counsel, we represent the plaintiff in today's case, Jordan Fuller. I want you to meet him. Mr. Fuller, could you turn on your camera? This is Jordan Fuller. Sam Fuller is his son. Sam loves to swim and climb and run. He's like most kids his age. Except that when he was 2 years old, Sam was diagnosed with a severe peanut allergy. Since then, protecting Sam has become a part of this family's everyday routine. Thank you, Mr. Fuller. Today, we are going to prove that the defendant, Coslo Grocery, is responsible for Sam Fuller's injuries. Now, as the plaintiff, we have the burden of proof. We have to show you it's more likely than not that it was the defendant's negligence, their carelessness, that caused Sam Fuller to have an almost fatal allergic reaction. Today, we're going to meet that burden. We're going to meet that burden by proving 3 simple facts. The defendant knew that food allergies are dangerous. They created a policy of hiding allergen information from their customers. And on July 3rd of 2019, the Fuller family had no warning that those samples contain peanut flour. So let's take those one at a time. The first fact we're going to prove to you today is that the defendant knew food allergies are dangerous. You're going to learn that back in 2017, the defendant, well, they were sued after a man walked into their store, took a sample, and had an allergic reaction. To settle that lawsuit, the defendant promised, from here on out, we will display allergy warnings anytime one of our samples contains a known allergen, including peanut flour. Now, the second fact that we're going to prove to you today is that after making that promise to their customers, the defendant created a policy that hid allergy information from those customers. You're going to learn that from a product warning specialist, and you're going to get a chance to see the language from the employee's training manual. It says, check the sample for these main allergens. And if you see one, put the product packaging where no one can see it. Put the ingredients list where no one can see it. And do not tell the customers about the allergen. Now, we questioned the defendant's CEO under oath. We asked her, ma'am, why do you tell your employees to put the allergy information where people can't see it? Her answer, I think I'll make more money. That brings us to the third fact that we're going to prove to you today. That on July 3rd of 2019, the Fuller family had no warning that the samples the defendant was providing had peanut flour. Today, you're going to learn it's actually part of the defendant's policy that the only thing that can be on those sample carts with the samples are written allergy warnings. And folks, those warnings are great. Bright red, all caps, real easy to see. But today, Jordan Fuller is going to testify that on that day, the defendant never put them up. Now, I expect throughout today's trial, the defense is going to dispute that. So I want you to remember that today, not a single witness is going to take that stand, raise their right hand, and tell you, I saw warning signs on July 3rd. Not a single witness is going to take that stand and tell you, I put up allergy warnings on July 3rd in Coslo. In fact, what the evidence is going to show is that the employee who was working at the sample cart that day never even bothered to go get those allergy warnings from his supervisor before starting his shift. That's why on July 3rd, Sam and Jordan Fuller had no indication, no warning that those samples had peanut flour. Now, folks, I want to be clear. Mr. Fuller, he could have asked. He could have asked if those samples had peanuts. But what the evidence will show is that the only reason he made that mistake, a mistake that he is going to admit that he made, the only reason he made that mistake is because he trusted this defendant. He had shopped at Coslo hundreds of times. He knew anytime a sample contained peanuts, he could expect those bright red, all caps warning signs. He relied on them. But on that day, when they walked up to the sample cart and saw no signs whatsoever, he thought that was the defendant telling him, this is safe. Members of the jury, at the end of today's trial, we're going to ask that you find the defendant liable for Sam Fuller's injuries. Because when they knew the danger, they hid the danger. Thank you for your time.
The court will recognize defense counsel for opening statement.
May I proceed?
You may.
Only one person could have prevented this. Now, you've just heard a story from plaintiff's counsel about a grocery store that hid information. And before we talk about Coslo Grocery, I want to make something very clear. We are so sorry for what happened to Sam Fuller on July 3rd of 2019. No child should ever have to go through what Sam Fuller went through that day. But today, you'll hear that plaintiff just misled you in their opening statement because they didn't tell you how Jordan Fuller failed to do what a reasonable parent would do on July 3rd. Members of the jury, today you will be asked to decide who was responsible for what happened to Sam Fuller that day. A grocery store that's been serving countless customers for nearly a century, or a parent who knew his child had a peanut allergy, but on July 3rd handed his child a light brown colored bar without asking, does this have peanuts? I'd like to talk about Coslo Grocery. It's a grocery store that's right here in Waco, Texas, that's been operating for nearly a century. It's a family-owned business, and today you'll meet Parker Hudson, the owner of Coslo Grocery, who left a successful career in Houston to return to her hometown and raise her family in the place where she grew up, and to take over the business that her parents had been running for nearly 5 decades. Now you'll hear how much Coslo cared about its customers. which is why Coslo took its policies around food samples very seriously. You'll hear that Miss Hudson understood that the hundreds of customers that came through her door had a wide variety of diets, sensitivities, and allergies, which is why she understood that the most important thing at the food sample stands at her store was to station an employee at that sample stand, so that employee could answer any question that any customer might have about their particular diets, preferences, sensitivities, or allergies. And that employee also made sure that the food samples that they put out were clearly visible so that the customer could see exactly what they were going to get. And Coslo also made sure that that employee had the packaging readily available in case a customer had questions about Coslo's product. On July 3rd, Coslo Grocery did what it always did. It stationed an employee behind that sample stand. It offered samples that were clearly visible to customers, and it ensured that the packaging for those samples were available to the customer. But on that day, Jordan Fuller didn't do what a reasonable parent of a child with a peanut allergy needs to do. See, today you'll hear that Jordan Fuller knew his child had a peanut allergy. Sam Fuller had been diagnosed with that peanut allergy when he was 2, and for nearly 8 years, the Fullers had been managing Sam's peanut allergy. You'll hear today that the Fullers knew it was important to keep their son away from peanuts in any form. It's why they knew it was important to ask questions. It was important to investigate packaging labels and make sure there wasn't peanuts. It was important if the Fullers went to a restaurant, they knew to ask questions about the food before they gave things to their son. And just to be safe, you'll hear today that the Fullers carried both Benadryl and EpiPens on them at all times. But on July 3rd, Jordan Fuller didn't do what he knew he needed to do. That day, you'll hear that the whole Fuller family visited Coslo Grocery. It was the day before 4th of July, and the Fullers were preparing for their annual 4th of July celebration. Jordan Fuller and his son headed down an aisle and approached a Coslo sample stand. And sitting on that sample stand was a protein bar. And members of the jury, I want you today to see exactly what Jordan Fuller saw that day sitting on the sample stand at Coslo. A protein bar, clearly visible, dark brown on the outside and light brown on the inside. You'll hear today that Jordan Fuller saw that protein bar. He saw the employee standing behind the sample stand. But Mr. Fuller didn't ask that employee, does this bar have peanuts? Mr. Fuller didn't ask if he could see an ingredient list for that bar. Instead, Mr. Fuller just took 2. One for him and the other one he handed to his 9-year-old son. Now you'll hear today it didn't take long for Sam to realize that something was wrong. He turned to his dad and he said, I think I might have eaten peanuts. And Mr. Fuller's first response was to disagree with his son. But after Sam insisted, Mr. Fuller returned to that sample stand. And when he went back, that same employee was still stationed there. We'll hear today that Mr. Fuller then asked for the first time, what's in this bar? And that's when the employee behind the stand, well, he handed Mr. Fuller the packaging for the bar. And that's when Mr. Fuller learned that he had just handed his child peanuts. But you'll hear next that the Fullers, they didn't call Sam's doctor. They didn't call an advice line. They didn't pull out their phone to Google, what do I do when my child who has a peanut allergy eats a bar with peanuts? Instead, the Fuller family simply returned home. And you'll hear that even though the Fullers had had a Benadryl on them, they waited until they had returned home to give Sam that Benadryl. You'll hear that they waited and they watched Sam. They watched as their son started to have trouble breathing. They watched as their son vomited before finally giving Sam the EpiPen that the Fullers had had the entire time. And it wasn't until their son's lips had turned blue that the Fullers finally called 911 nearly 30 minutes after returning home. Members of the jury, Mr. Fuller is now asking you to hold Coslo responsible for what he handed his child on July 3rd. But the evidence will show that Mr. Fuller failed to do what a reasonable parent with a peanut allergy needs to do. That's why you'll hear from two expert witnesses today who will both discuss the important role that parents play in protecting their children. You'll hear from Dr. Robin Isbell, a pediatrician who specializes in childhood allergies. And Dr. Isbell will tell you that parents are the first line of defense. And that's why a parent should never hand their child something without asking, does this have peanuts? On July 3rd, only one person could have stopped Sam from eating that bar, and only one person could have gotten Sam the help that he needed. And that's Mr. Jordan Fuller. Which is why at the end of today's case, my co-counsel, Ms. Virginia Lyon, is going to ask that you find Coslo not negligent. Thank you.
All right, plaintiffs, who will be your first witness?
Your Honor, we're going to call Jordan Fuller to the stand, but before we do, to open our case, we'd like to read onto the record two stipulations.
Proceed.
Stipulation 5 reads, plaintiff and defendant stipulate that Sam Fuller has a peanut allergy and had that allergy on the date in question, July 3rd of 2019. Stipulation 6 reads, plaintiff and defendant stipulate that Sam Fuller's peanut allergy caused or contributed to cause the allergic reaction he experienced on July 3rd of 2019. And with that, the plaintiff calls Jordan Fuller.
Mr. Fuller, I'll remind you that you were previously sworn and you are still under oath. Counsel, you may proceed.
Good afternoon.
Good afternoon.
Please introduce yourself to the members of the jury.
Hello, my name is Jordan Fuller.
Where do you live?
I live here in Waco. My wife, Drew, grew up here.
Do you and Drew have any kids?
We do. We've got 3 kids. James is our eldest. He's 14. Sydney's our troublemaker. She's 12. And then Samuel, he's the baby. He's just 10.
I want to get to know Sam. In your electronic notebook, could you find exhibits 1A and 1B? Let us know when you have them.
I have them here.
Do you recognize these photographs? What are they?
Of course I do. These are pictures of Sam.
Your Honor, at this time, the plaintiff offers exhibits 1A and 1B into evidence.
Any objection?
Yes, Your Honor. We would object to having exhibit 1B be admitted at this time, as having 2 images of Sam Fuller, I think, would be cumulative.
May I respond, Your Honor? I'm sorry, Your Honor. I'm not sure I could hear you. May I respond on those grounds? Your Honor, Sam Fuller won't be testifying, so the members of the jury are entitled to get to see what he looks like. Now, we're not going to be showing photographs of what Sam looked like after the event or anything prejudicial, and it's certainly not, cumulative for us to simply just show 2 photographs of Sam Fuller.
The objection is overruled. Those will both be admitted.
Could we publish those for the members of the jury?
Okay.
All right. So what can you tell us about Sam?
He's a lovely kid. He's so active. He loves to play basketball. He loves to swim and climb. That first one, 1A, that's from a camping trip we all took last year. 1B's from around Christmas time, obviously. He can be a handful, Sam, but he's great.
Does Sam have any health issues?
He does. When he was 2, he was diagnosed with a peanut allergy. The doctor told us to keep him away from peanuts in all forms: peanut oil, peanut butter, peanut flour, all of it.
Why did you bring this lawsuit here today, sir?
On July 3rd of last year, 2019, I was shopping at Coslo Grocery with Sam. And I gave him a sample from their sample stand because there were no warnings up. So I didn't know that it had peanuts in it. Sam ended up in the hospital.
I want to start from the beginning. Now, you said that you were shopping at the defendant's store, Coslo. What is Coslo?
It's one of those big box sell everything kind of stores. They've got TVs, they've got glasses, but they've also got food.
Had you shopped at Coslo before the day that Sam got sick?
Oh, hundreds of times. It was our regular grocery store, so I was there all the time.
When you had shopped there in the past, how often did you see the defendant giving out food samples?
All the time.
So before the day Sam got sick, how would you know if a sample had something he couldn't eat?
Well, I relied on the warnings. If the warnings were there, I knew it was something that Sam could be allergic to. If they weren't there, it was safe.
I want the members of the jury to see what you would see in the defendant's store. Sir, could you find Exhibit 6 for me and let us know when you have it?
I have it here.
What is Exhibit 6?
It's one of the sample stands that they'd use at Coslo.
And if you could find Exhibits 11 and 12,
I've got those.
what are they?
Those are the warning signs that I would see up.
Do these look to be fair and accurate depictions of what you would see inside of Coslo when you shopped there before Sam got sick?
Yes, when the samples had allergens in them, this is what I'd see.
Your Honor, at this time, the plaintiff offers Exhibits 6, 11, and 12 into evidence.
Are there any objections?
No objections.
They'll be admitted.
Could we put up Exhibit 6 for the members of the jury?
Feel free to use any exhibit that are admitted, counsel. Thank you.
Now, if we could go ahead and display those warning signs for the jury to see. Thank you. Now, Mr. Fuller, if you had that photograph of the sample cart, do you think you might be able to show the members of the jury where you would see these warning signs when you shopped at Coslo in the past?
Yes, I reckon I could do that.
Your Honor, permission for this witness to share his screen and make use of the demonstrative that we mentioned in pretrial using these exhibits that have been entered into evidence.
Any objection to the demonstrative, counsel?
No, Your Honor.
You may proceed.
All right, so we have the sample cart from Exhibit 6 and the warnings from Exhibits 11 and 12. Mr. Fuller, do you think you could drag those warning signs onto the photo to where you would see them generally when you shopped at Coslo before Sam got sick?
Just drag them straight in?
Yes, sir.
Sure. So there were both warning signs up on the cart like that.
Now, if you could drag that word samples and show us where you would see samples when you shopped there before.
So the samples would go on the cart too, like that.
Your Honor, may we preserve this for use in closing argument?
Yes, you may.
Thank you, Mr. Fuller. You can close that document now. So I want to talk about what the defendant did on the day that your son got sick. What was that date?
July 3rd, 2019.
Why were you at Coslo that day?
We were shopping for our annual 4th of July barbecue. As you can imagine, my family likes to make a bit of fun of me for Americans' Independence Day.
So what happened after you walked in to the defendant's store with your family?
Well, we split it up. Drew took James and Sydney to go get sausages, that sort of thing. And I went with Sam to go get plates and cups. And on the way, we stopped at a sample stand.
What kind of samples?
The employee said they were gluten-free protein bars.
I want the members of the jury to see what those samples looked like. Could you find Exhibit 9 and let us know when you have it?
I have it here.
What is Exhibit 9?
This is a photo of the protein bars that they were sampling that day, or at least that's what they look like.
Does this look to be a fair and accurate depiction of the samples you saw when you walked up to that cart with Sam?
Yes.
Your Honor, at this time, the plaintiff offers Exhibit 9 into evidence.
Any objection?
No objections, Your Honor.
It'll be admitted.
Ms. Gold Diamond, could we put that photo up for the members of the jury? Thank you. Now, Mr. Fuller, if you had that photo of the sample cart from earlier, could you show the members of the jury what you saw on the day that Sam got sick?
Yes, I could do that.
Your Honor, permission for this witness to share his screen and make use of that second demonstrative, similar to the first, but this time concerning July 3rd of 2019.
Any objection to the demonstrative?
No, Your Honor.
You may proceed.
Go ahead, Mr. Fuller. Okay, so now we have the warning signs, we have the sample cart, and now the samples. Mr. Fuller, on July 3rd of 2019, where were the samples?
Well, the samples were right on the cart, just like normal.
And the warnings?
There were no warnings.
Your Honor, may we preserve this demonstrative for use in closing argument?
You may.
And Mr. Fuller, when you saw what you're seeing on your screen, the samples and no warnings, what were you thinking?
I thought that it meant it was safe. I thought it meant that there were no peanuts in there.
So what did you do?
I took one of the samples for myself, and I gave one to Sam.
You can close that document. Thank you, sir. I want to talk about what happened next. What happened after Sam ate one of the defendant's samples?
Well, after I gave Sam the sample, we walked away at first, but then Sam told me he thought that the bar had peanuts. So I went back over and I asked the employee if it had peanuts in it.
And what did the defendant's employee say?
He told me he had no idea.
So what did you do?
Well, after that, the employee pulled out the packaging and he handed it to me. And I read the box. Peanut flour.
What did you do when you realized that Sam had just eaten something with peanuts?
We went straight home. I gathered up Drew and the rest of the kids. We kept an eye on Sam, obviously. At first he was fine, but after about half an hour, his breathing started getting a little difficult. That's when we used the EpiPen on him. When his lips turned blue, we called 911.
Mr. Fuller, in their opening statement, the defendant said that it was your mistake that caused Sam Fuller's injuries. Do you think that you made a mistake that day, sir?
I do.
What was it?
I never should have given Sam that sample. Not without knowing the ingredients first. I regret it every day. I never should have given him that sample.
Mr. Fuller, why were you willing to let Sam try one of those samples without reading the ingredients?
Because I thought it was safe. There were no warnings up. I'd shopped there hundreds of times in the past. There had always been warnings up when something was dangerous for Sam. Since there weren't any, I thought it meant there were no peanuts.
Thank you, Mr. Fuller. Your Honor, we have no questions at this time. Pass the witness.
Cross-examination,
May I proceed?
you may.
Mr. Fuller, I'd like to ask a few questions about your son's peanut allergy.
Of course.
Sam was diagnosed when he was 2,
Yes.
and when he was diagnosed, the doctor told you to keep Sam away from peanuts in any form.
Right. Peanuts, peanut oil, peanut flour, anything that came from peanuts.
I'd like to talk about how you and your family managed Sam's peanut allergy up to July 3rd. You said that you knew it was important to keep Sam away from peanuts.
Of course.
So you would never hand something to Sam that might have peanuts.
Right. We didn't buy anything that had peanuts in it. If we were at a restaurant, we wouldn't get something unless we knew there were no peanuts in it, that sort of thing.
I'd like to follow up on that. If you were at a restaurant and you didn't know what was in the food, you knew you had to ask.
Right. If we didn't know if it had peanuts in it or not.
So you sometimes had to ask the waiter, does this have peanuts?
Yes.
Because you couldn't check an ingredient list.
Right. Of course. If we didn't know.
You and Drew also carried Benadryl on you.
Oh, yes. We carried Benadryl and EpiPens with us at all times.
And you got a prescription for those EpiPens.
Of course.
You knew that those EpiPens could help prevent anaphylactic shock.
Right. If he had a bad reaction, we could use the EpiPen.
And that's why you carried them on you at all times.
Right. And we made sure that the nurses at Sam's school had one. We just wanted to make sure that there was always someone nearby who'd have one, just in case he needed it if he had a bad reaction.
I'd like to turn now to talking about July 3rd. Your family visited Coslo that day.
Yes.
It was a busy day.
Of course. It was the day before July 4th.
You and Sam went off to get paper plates and paper cups,
Right.
and you passed a sample stand.
Yes.
Your Honor, permission to share Exhibit 10, which has been pre-admitted by counsel.
Proceed.
Mr. Fuller, is this the sample you saw on the stand?
Right. That's just one of them. Yes. There were more than that, but yes.
This is the one of the several that you saw.
Right. That's not the exact one, but that looks like what I saw.
And you could see it clearly.
Yes.
Nothing was covering the bar.
No, that was actually the only thing that was out. It was just the bars.
So you could see that the bar was dark brown on the outside.
Yes, it looked like a candy bar to me.
And you could see that it was light brown on the inside.
Right.
And you'd agree that it's a light brown colored bar.
Yes, dark brown on the outside, light brown on the inside, yes.
And Mr. Fuller, you've seen peanuts before, correct?
Of course.
Now, Mr. Fuller, you also knew that there was an employee standing behind the sample stand.
Yes, he was there.
You knew you could talk to him.
Right, he was the one who told me that they were protein bars.
You knew you could ask him questions.
Yes?
But you didn't ask him, does this bar have peanuts?
No, I thought it didn't.
You didn't ask the employee, can I see the ingredient list?
No.
You took 2.
Yes, one for myself and one for Sam.
Now, you testified that on direct examination that Sam could tell that something was wrong after he started eating the bar.
Right, he thought that he could smell peanuts. That's what he told me anyway.
But you disagreed with him.
It tasted like caramel to me when I tried it, but I wasn't going to ignore him, so when he told me that it smelled like peanuts, I went back over to the stand.
And when you went back over to the stand, the employee was still there.
Oh, yes.
And the employee gave you the packaging for the bars.
Well, I asked if it had peanuts, and he told me that he had no idea, and then he handed me the packaging. Yes.
Yes or no, he handed you the packaging.
Right, from underneath the cart.
And that packaging contained the ingredient list.
Yes, it did.
And that's when you learned that you had handed your son peanuts.
Yes.
I'd like to walk through what happened next. To confirm, this was the first time to your knowledge that Sam had eaten peanuts.
Yes, when he'd been diagnosed, he hadn't eaten any peanuts, so this was the first time.
So you didn't know how he would react.
Right, that's why we wanted to really keep an eye on him. We went home straight away, just check in and see what was happening.
And Mr. Fuller, you didn't contact anybody at the store to tell them that your son had just eaten peanuts.
And not then, no. We were more focused on Sam than the store.
You didn't ask somebody to call an ambulance.
No, Sam seemed to be doing fine. It had been a couple of minutes, so we were watching and making sure we knew what was happening. We were ready.
So when you got home, you gave Sam a Benadryl.
Right. We went home. He still seemed to be entirely normal, but I gave him a Benadryl just to be careful.
And I'd like to take this sequence one piece at a time. You gave him the Benadryl after you returned home.
Right. We got home. He'd been fine and he didn't have any symptoms, but we wanted to be really careful, so we gave him one of the Benadryls we had there.
Mr. Fuller, I'm going to ask you questions one at a time, and a simple yes or no answer I think would be helpful. You gave Sam a Benadryl after you returned home.
Right.
You had a Benadryl on you while you were at Coslo, correct?
Oh, yes, of course.
You then waited to give Sam an EpiPen.
Well, yes, he was still okay.
You waited until Sam started to have trouble breathing.
Right. He had trouble breathing and then he vomited and then we used the EpiPen.
And then you waited before calling 911.
Well, we took him upstairs and he was still having trouble breathing and it was clearly getting more difficult.
Mr. Fuller, after administering the EpiPen, you waited to call 911, yes or no?
Well, I wouldn't say we waited. We saw that the symptoms were still getting worse. My wife tried to do CPR and I called 911.
But Mr. Fuller, to confirm, you didn't call 911 until your son's lips had turned blue, yes or no?
Well, right. We used the EpiPen and it clearly didn't work, so we called 911.
Your Honor, motion to strike is non-responsive, everything after the yes or no response.
Sustained.
Mr. Fuller, after you called 911, Sam's lips had turned blue, yes or no?
Yes.
And Mr. Fuller, at no point did you pull out your phone to Google, what should I do when my son with a peanut allergy eats peanuts?
Well, the doctor had said to use the EpiPen, and we tried that, and when it hadn't worked, that's when we'd called 911.
And Mr. Fuller, you didn't actually call Sam's doctor to ask him what to do after Sam had had that peanuts, though.
Well, no, it was an emergency at that point. I wanted to call 911 and get an ambulance, not a doctor he'd had 8 years ago.
But Mr. Fuller, you were home for 30 minutes before you called 911, is that right?
Right, monitoring him.
Mr. Fuller, I'd like to turn now to what happened after Sam recovered. You hired a lawyer.
Yes.
We're here today because you are asking the jury to hold Coslo responsible for what happened on July 3rd.
Yes.
Your Honor, permission to share constructively just with the witness what has been pre-marked as Exhibit 14.
Proceed.
Mr. Fuller, on October 15th of 2019, you made a Facebook post. Is this a copy of that Facebook post?
Yes, that's a Facebook post I made.
Is this a fair and accurate copy of that Facebook post?
It looks like it, yeah.
Your Honor, defense offers to move Exhibit 14 into evidence.
Any objection?
Without objection, Your Honor.
It'll be admitted.
Mr. Fuller, October 15th, this was about 3 months after the allergic reaction your son had on July 3rd. Is that correct?
Yes.
This is that Facebook post you made that day.
Right, like I said.
And Mr. Fuller, you wrote of your son, he almost died because I gave him something to eat without knowing there was peanut flour in it. Did I read that correctly?
Yes, that's what I wrote.
And Mr. Fuller, you at no point in this Facebook post mentioned Coslo Grocery. Is that right?
That's right, not in that post.
Thank you. Nothing further.
Redirect?
Yes, Your Honor. Ms. Gold Diamond, could we put up Exhibit 14, what was just in front of the jury? Thank you. Mr. Fuller, opposing counsel just asked you about this exhibit. You wrote that Sam almost died because I gave him something to eat without looking at the ingredients first. Sir, why didn't you know that there was peanuts in that sample?
Because there were no warning signs.
Thank you, Mr. Fuller. Your Honor, we have no further questions. May Mr. Fuller be excused?
You may. Who will be your next witness?
The plaintiff calls Kelly McKagan.
All right. I will remind you that you are still under oath. You may proceed, counsel.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Of course. Hello, I'm Kelly McKagan.
What do you do for a living?
I'm a professor of industrial engineering at Auburn University, where I study product warnings.
What exactly is a product warning?
A product warning is a sign, it's a label, it's a symbol, it's really anything that can communicate a product's dangers to customers.
Doctor, what's your involvement in this case?
I was hired to examine whether Coslo Grocery adequately warned the Fullers about the peanut flour in their food samples.
Before we get into your analysis, I want the jury to have a sense of your credentials. Where'd you go to school?
I went to Auburn University. There I got my bachelor's degree in management, and then I went on to get my master's and PhD in industrial and systems engineering.
What's industrial and systems engineering?
It's a field of science that tries to make things work better. I use it to try to make things safer. Everything from how do you design a safer can opener to what size stop sign should be.
Doctor, you said before that your focus was on product warnings. Could you describe your professional experience in the area of product warnings?
Absolutely. As a professor, I study product warnings. As a consultant, I work with companies to perfect their product warnings. And then as an expert witness, I evaluate whether warnings are adequate.
Are you a member of any professional organizations that work with product warnings?
I am. I'm a member of the American Society of Safety Engineers and the National Safety Council.
How many years have you been studying product warnings?
I've been doing this for 15 years.
Your Honor, the plaintiff tenders Dr. McKagan as an expert in product warnings.
Any objection?
Just one, Your Honor. In order to be tendered under 702, this expert has to tell us what analysis he performed in today's case. I don't believe we've heard sufficient foundation about the exact analysis this expert performed in today's case.
May I be heard, Your Honor? Your Honor, counsel misstates the rule. Under 702A, we've satisfied the requirements for this witness to be tendered as an expert. And after we've done so, we will go through his methodology to meet the other requirements of 702.
All right, the objection is overruled. Please proceed.
Doctor, now I want to understand how you performed your analysis. What information did you look at?
I looked at the deposition of Jordan Fuller. I had the statements of the defendant's CEO and the employee who was working the sample stand that day. And I reviewed photos of the defendant's store.
What principles and methods did you use to evaluate that information?
I used a 3-step process. Identify the danger that the company's trying to warn customers about, identify what warnings are in place, and evaluate whether those warnings adequately communicate that danger.
Doctor, are you an allergy expert?
No, I'm not a medical doctor or a food allergist.
So how were you able to perform that first step of identifying the danger?
My work isn't about diagnosing the danger. It's about identifying what danger the company's trying to communicate and then determining whether it was adequately communicated. For example, I once testified in a case where a child fell into a pit of chemicals. My job there wasn't to determine whether those chemicals were dangerous. It was to determine whether the warnings around the pit were adequate.
Well, what danger was the defendant trying to warn customers about in this case?
Peanut flour. The defendant's CEO says that it's a common and dangerous allergen and that it's their policy to warn customers about it in food samples.
That 3-step process you described, is that a standard method in your field?
Yes, it is.
Did you apply that method reliably to the facts you looked at?
I did.
Were you able to form a conclusion?
Yes, I was.
Did you form that conclusion to a reasonable degree of certainty in your field?
Yes.
So, doctor, tell the jury, what did you conclude?
Well, I concluded that the defendant did not adequately warn the Fullers about the peanut flour in their food samples.
I want to break that down, starting with the defendant's policies. You said the defendant has a policy to warn customers about allergens, but what policy were you referring to specifically?
The sample stand policy. The defendant's CEO says that it's their policy for employees to check the ingredients that are in samples, and if they see an allergen like peanut flour, they're supposed to put out warning signs with the samples.
Do you know why that's the defendant's policy?
Yes. In 2017, a customer came into the defendant's store, ate a food sample, and had a severe allergic reaction after there were no warnings. There was a lawsuit, and in order to settle the suit, the defendant promised to warn future customers about allergens in food samples.
So if a company like the defendant wants to warn its customers about food allergens, what are the ways they can do that?
There are several. They could give a verbal warning, they could have up written warnings, or they could just display the product packaging or ingredients list.
Doctor, based on the evidence you reviewed, how many of those 4 types of warnings did the defendant provide on July 3rd, 2019?
0.
Well, let's take them one at a time, starting with the verbal warning. How do you know the defendant didn't instruct its employees to just tell the Fullers, there's peanuts in this?
The defendant's CEO says they didn't do that. It's their policy not to, and it's even in their employee handbook. Do not give customers verbal warnings.
What about displaying the packaging or the ingredients list? How do you know the defendant didn't do that?
Again, the defendant's CEO says it's their policy not to. Never display the product packaging, never display the ingredients list.
Does the defendant's CEO say why it's their policy not to display packaging?
She does. The defendant's CEO says that if they display the packaging, the cart will look more cluttered. She says they make more money if they don't display the packaging.
Objection, Your Honor. At this time, I object to hearsay. May I explain?
May.
While experts can rely on hearsay in coming to their conclusions, they can't be used as a conduit for hearsay. At this point, this expert is being used to backdoor hearsay testimony from another witness who will be on the stand, and plaintiff will have an opportunity to ask her about these opinions then.
Response?
Yes, Your Honor, I would respond on 2 grounds. First, pursuant to Rule 703, this witness as an expert is allowed to rely on otherwise inadmissible testimony to form his conclusions, as long as the probative value of those outweighs the prejudicial value, which it does. And second, this testimony, it's not even inadmissible, because all of these are statements made by our party opponent in this case. So they all fall within 801D2.
The objection is overruled. You may proceed.
So, Dr. McKagan, what did the defendant's CEO say about why they had a policy of not displaying the packaging?
Well, like I just said, the defendant CEO says they make more money if they don't display that packaging.
What about the ingredients list?
The same reason. The defendant CEO says they make more money if they don't display the ingredients lists.
Now, you testified that the 4th type of warning the defendant could have provided was a written warning. Mr. Trevisani, if you could publish Exhibits 11 and 12, they're already in evidence. Doctor, what are we looking at here?
These are the written warnings that, according to the defendant's policy, they were supposed to have up next to those samples on July 3rd, 2019.
Doctor, you said the defendant was supposed to display these warnings. Is there any evidence that they actually did?
I found essentially no evidence that they actually displayed these warnings.
What do you mean?
Well, Jordan Fuller says that there were no warnings up that day. And the defendant's statement provides no evidence that the warnings were up.
What do the defendant's statements say about whether the warning signs were displayed?
The defendant's CEO says that she wasn't at the store on July 3rd. The employee who was working the sample stand that day says he can't be certain that he put the warnings up. And the supervisor who was supposed to give the employee those warnings at the beginning of his shift wasn't interviewed. So as far as I know, the employee never even had those warnings in the first place.
Doctor, I want to bring this all together. How were you able to conclude that the defendant failed to adequately warn the Fullers about the presence of an allergen in those food samples?
Per the defendant's own policy, they were supposed to provide a written warning. I found no evidence they provided the Fullers with any warning.
Thank you. I have no further questions. Pass the witness.
Cross-examination?
Yes, Your Honor. Dr. McKagan, you're an academic, right?
I'm a professor and a consultant.
Even so, you've never taught a class on food allergies,
That's true.
on food allergy labeling.
That's true as well. I'm a professor of industrial engineering.
You've never taught a class on grocery store best practices either.
That's true.
Never conducted a study on any of those things.
Right. Again, I study product warnings generally.
Never written a paper on any of those things.
Right. Again, just product warnings generally.
So you've never written a paper on product warnings concerning any of those things.
Right. That's true.
You've never testified about any of those things before either.
Well, I've testified about product warnings before, but not about grocery stores or food allergy warnings. That's true.
Dr. McKagan, you've testified in about 200 cases in your career, right?
I've been hired in around 200 cases. I didn't testify in all of them. They didn't all go to trial, but I've been retained that number of times. That's true.
And when you're retained, I'm sure you want to do a good job.
Of course.
That means being thorough,
That's right.
being accurate,
Yep.
getting all of the necessary information.
That's right.
So I'd like to talk about what you did in today's case.
Okay.
For today's case, you reviewed some documents and some pictures, right?
Right. I reviewed the deposition of Jordan Fuller, the defendant's CEO, and then photos of the defendant's store.
These are all documents and photographs that plaintiff's counsel gave you. Is that right?
That's true.
All right, I'd like to talk about what you didn't do.
Okay.
You mentioned there was an attendant at the sample stand on July 3rd. You didn't interview that attendant, right?
No, I got the statements of Casey McCain from the deposition of Parker Hudson, who talked about them then.
Directing you back to my question, it's just a little more simple. You didn't interview that attendant that was working the sample stand on July 3rd, correct?
Right, like I said.
You also mentioned the attendant supervisor on direct examination, and you said you didn't get to read anything that attendant said, right?
That's true.
But you didn't go out and interview that supervisor before today's trial.
I didn't, that's right.
You didn't interview anyone who works at Coslo, right?
No, I reviewed the deposition of their CEO, but I didn't interview her personally.
Directing you back to my question, you didn't interview anyone who works at Coslo, right?
Right, like I just said.
You didn't talk to anyone who was in that grocery store on July 3rd. Is that right?
Well, I reviewed the deposition of Jordan Fuller. I didn't interview him personally, but I did review his statements.
Dr. McKagan, directing you back to my question. You didn't interview a single person who was in that grocery store on July 3rd. Is that right?
Right.
Even so, you came to some conclusions. You just told us on direct examination, I found no evidence that they displayed these warnings. I'd like to talk about that.
Okay.
Now, you said the attendant couldn't be sure whether he put that warning sign up, but actually, he believes he put that warning sign up. Isn't that right?
Objection, Your Honor. This is speculation.
Response?
Your Honor, this expert witness came to the conclusion on direct examination that this attendant didn't know. I'm simply interrogating that conclusion based on the evidence he reviewed.
I'll overrule the objection. Proceed.
I'll ask it again. You're aware that the attendant who put that warning sign up believes he put that warning sign up. Is that right?
No, that's not true.
It's your testimony today, Dr. McKagan, that attendant doesn't believe he put the warning sign up.
No, what Casey McCain says is he thinks he put the sign up, but he can't be sure.
So Dr. McKagan, the attendant who worked that sample stand thinks he put the sign up. Is that right? That's what you just said.
Right, that he thinks he did, but he can't be sure.
And again, you didn't interview that attendant to see whether or not that was true, did you?
No, I didn't.
You're also aware that attendant said it was his practice to always put a warning sign up, right?
That's true.
Regardless of whether there was an allergen present in the food.
That's right. He said he usually put it up, but he couldn't be sure on July 3rd.
Sharing my screen to show the court what has already been admitted into evidence as Exhibit 10. Dr. McKagan, you reviewed this picture of the protein bar and coming to your conclusions today?
I did.
You'd agree with me, Dr. McKagan. This protein bar looks like it could have peanuts in it. Is that right?
It's light brown. That's true.
Directing you back to my question, this looks like it could have peanuts in it, right?
Sure.
Sure or yes?
Yes.
Now, Dr. McKagan, you believe that when parents are out in the world, it is their responsibility to take care of their children, right?
That's true. Parents definitely have responsibilities to keep their kids safe.
You also believe that sometimes warning signs, they're not enough.
That's true. It would depend on the facts of the specific case, but certainly there are circumstances where warnings alone aren't enough.
You believe what is needed is common sense.
Well, it depends on the facts of the case, right? Because some things are common sense, but some things just aren't. So I guess it depends on what you're asking about.
Dr. McKagan, it's your personal opinion that people need to exercise common sense.
Yeah, generally, I think people should use common sense.
No further questions at this time, Your Honor. Defense passes the witness.
Any redirect?
No redirect, Your Honor. May the witness be excused?
You may. Who will be your next witness?
Your Honor, that concludes the plaintiff's case in chief. We have no further witnesses and we rest our case.
All right, thank you, counsel. All right, may I get a time check, please? Mr. Ruiz.
Yes, hi. After the plaintiff's case in chief, they have 33 minutes and 47 seconds remaining, and the defense has 39 minutes and 26 seconds remaining.
Thank you. All right, we're going to take a very short recess in between plaintiff and defense case, 5 minutes for all of us. I'm going to keep you to 5 minutes. So I'll come on just a little bit shy of that and make sure we're all getting back on and ready to go. We'll be in recess.
Thank
Yes,
you,
Your
Your Honor.
All right, before we proceed, I'm just going to make sure I've got all my judges back. Let me check in. All right, I've heard from a couple of you. I see a couple of you. David, I've got you. Mark, are you on?
Yes, I'm here. Sorry.
Good. All right, thank you. All right, let's proceed. Who will be the first defense witness?
Defense calls Parker Hudson to the stand.
I'll remind you, Ms. Hudson, that you're still under oath. You may proceed, counsel.
Ms. Hudson, can you introduce yourself to the jury?
Sure. Hi, I'm Parker Hudson.
Ms. Hudson, what do you do?
I run Coslo Grocery.
For those of us who have never been to Coslo Grocery, what can you tell us about your company?
I like to say it's Waco's favorite grocery store. We have been operating in this community for just about 100 years now, and I'm proud to say that we are a family-run business.
What do you mean by a family-run business?
Well, my dad used to work at the store, actually. He started there as a stock boy when he was young, worked his way up to manager, and eventually was able to buy out the store from the previous owners. And then he and my mom ran the store for about 50 years, believe it or not. I actually used to work there back when I was a teenager. I'd just stock the shelves and stuff.
What did you do after you worked there as a teenager?
Well, I went to college, went to Texas A&M, Gig'em, got a degree in finance, and then I stayed in College Station and worked in finance for about 20 years.
What brought you back to Waco and to Coslo?
My dad called me up one day and said that my parents were thinking about retiring and selling the store. And, you know, I was working crazy hours at the time and everything just seemed to kind of align. It was the perfect time to move back home, raise my kids close to their grandparents, and buy the store for my parents, keep it in the business, or keep it in the family, excuse me. So that's what I did.
How long ago was that?
It's about 10 years since we moved back to Waco.
And so how long have you been running Coslo Grocery?
10 years.
I'd like to turn now to talking about Coslo's food sample policies. How often does Coslo provide food samples?
All the time. We see it as a real win-win. You know, we like getting to offer our customers something that they can try without buying a whole box of it. And they love getting to try free food.
Who's in charge of setting policies around food samples at Coslo?
I am.
What can you tell us about Coslo's food sample policies?
Yeah, well, we have a few of them. The most important by far is that anytime we have a sample stand, there's an employee who's assigned to stand there and offer free food samples.
Why does Coslo require an employee to be at the stand?
We think it's really important that there's someone from Coslo there to answer any questions that the customer has. You know, if they want to see the ingredients list, the employee can pull it out and read it or just hand it to them. Or sometimes a customer just wants to know, you know, what aisle is this product in, or what should I cook with this? And so the employee's there to answer any of those questions.
How does the employee know what their responsibilities are while they're working at the stand?
Well, as with all of our employees' responsibilities, it's laid out in our training manual.
Your Honor, permission to publish Exhibit 19, which has been pre-admitted.
Okay.
Ms. Fuller, excuse me, Ms. Hudson, what are we looking at?
This is the Coslo Employee Training Manual, the version that we used in July 2019.
What section of the employee manual are we looking at?
It says right there, section 9. This is the sample stand section.
I'd like to turn to the second page. What can you tell us about policy 9.1?
So that's the section that says if you're the employee assigned to that sample stand, then you're responsible for following all the other rules that we have for sample stands.
I'm going to highlight that part. What about 9.2?
That section says that the employee should take the product out of the packaging and put it in single-size cups to put out on the stand.
Why is the employee required to put the sample out into cups?
There's a couple reasons. One is just, it makes it easier for a customer. It means that we can break it up into smaller pieces, so it's easier for a customer to grab one and eat it on the go as they're shopping. But the bigger reason is just, we think it's really important for them to see what it is they're about to put in their mouths.
What does the employee do with the packaging that the sample came in?
Yeah, so there's a rule for that too. It's not like they just throw it away or something. So that's in 9.3. It says, keep any such packaging under the sample stand. And the reason why is in the very next sentence. If a customer requests to see the packaging, then the employee can go ahead and hand it over.
I'm going to highlight that as well. Ms. Hudson, what does 9.4 of the policy cover?
That's the section that talks about our warning sign policy. So if a sample has a common allergen, then the employee should put a warning sign out.
Ms. Hudson, are you aware of any laws requiring Coslo's duty to provide warning signs on its stands?
No, I'm not aware of any legal responsibilities that we have in that respect.
Why does Coslo have language in their policy about warning signs?
Well, we added that language in 2017. That was the point at which we had a customer come into the store and eat something and have a serious allergic reaction to it. And so we actually worked with that customer as part of a settlement agreement to develop a warning sign policy to prevent it from happening in the future. And this is the policy that we agreed on.
Ms. Hudson, now that you've explained Coslo's policies, I'd like to ask a broader question. Why does Coslo have these policies around food samples?
Well, in short, we do it because we care about our customers. And of course, as with any grocery store, we get lots and lots of different customers. And we know that they have a wide range of dietary needs, allergies, but also just preferences or sensitivities. And, we can't know that about every person who comes in our door. So our policy is keep the food visible, keep someone there to answer any questions, and keep the ingredients list available. And we think that's just the best way to keep everyone safe.
I'd like to ask now about Sam Fuller's case. When did you learn that Sam Fuller had visited Coslo Grocery?
I first heard on July 4th, the day after the Fullers came into my store.
What did you learn?
Well, the Fullers' lawyer called me and said that the Fullers believed that Sam Fuller had gotten sick from something he ate at Coslo.
To be clear, what information did you have on July 3rd about Sam Fuller's allergic reaction?
None. I mean, I didn't have an employee tell me anything. There were no customer complaints reported, no ambulance called to the store, no one requiring medical attention. I mean, I didn't hear a single thing on July 3rd.
What about Jordan Fuller? What communications have you had with Sam Fuller's parent?
None. I've never spoken to Jordan Fuller.
Thank you. Nothing further at this time.
Cross-examination.
Yes, Your Honor. If I can just adjust my camera. All right. Sorry about that. Ms. Hudson, can you see and hear me okay on your screen?
Yes, I can. Thanks for checking.
Your Honor, may I proceed?
You may.
Now, Ms. Hudson, you're the owner of Coslo Grocery, right?
Yes, I am.
Now, on direct examination, you spoke about your policy when it comes to sample stands, right?
That's right.
You told the members of the jury, and I'm quoting here, "We do it because we care." That's what you said, right?
That's right.
Ma'am, the truth is, you instituted this policy to, in your own words, get rid of a lawsuit, right?
Yeah, that was one of the reasons.
You also said on direct examination, we don't have a legal responsibility to put up those allergy warnings, right? That's what you said.
As far as I know, I'm not a lawyer.
But as far as you know, ma'am, that settlement agreement, it's legally binding, right?
Again, I'm not a lawyer. What I meant was I don't think there are any laws that require grocery stores to put up signs on sample stands.
All right, I'm glad we could clear that up. So I want to start then talking about that agreement. Now, you'd agree with me, Sam Fuller wasn't the first person to get sick after eating a sample in your store.
That's true.
A man named Dennis Comer actually sued your company, right?
That's right. Back in 2017.
To settle that lawsuit, you promised, from here on out, we will put up warning signs if our samples contain known allergens, right?
That's right.
Your Honor, we're publishing Exhibit 18, which was pre-admitted pursuant to your pretrial order. Now, Ms. Hudson, this is the agreement between your company and Dennis Comer.
Yes, it is.
In this agreement, you promised to put up a warning sign anytime a sample contained an allergen in the Food Allergen Labeling and Consumer Protection Act, right?
That's true.
But ma'am, after you signed that document, well, you didn't go and read the Food Allergen Labeling Act, right?
No, like I said, I'm not a lawyer.
In fact, when you were deposed in this case, ma'am, despite that act being listed in the settlement agreement, you said, Food Allergen Labeling Act? Never heard of it, right?
That's right.
So let's talk about what your company did on July 3rd of 2019.
Sure.
Now, your company was handing out chocolate-covered protein bars, right?
Yes.
The employee who was working at the stand that day was a young man named Casey McCain, right?
Yeah. Great kid.
Your Honor, we're displaying Exhibit 19, which was already in evidence. Now, this is the employee training manual that you spoke about a few moments ago, right?
Yep. Same one.
Now, according to this policy, Casey McCain, he was supposed to check the ingredients, right?
That's right.
Those ingredients contain peanut flour in this case, right?
That's right.
But your manual says, do not provide any verbal warning about the presence of allergens, right?
That's true.
So when Jordan and Sam Fuller walked up to that sample stand, your employee, he wasn't supposed to tell them about the peanut flour, right?
No.
Your employee, excuse me, he had actually been trained not to tell them about the peanut flour, right?
That's right. That's what the warning sign is for.
So let's talk about those warning signs. Now, those were the warning signs you instituted after 2017, right?
Yes, exactly.
You'd agree with me when Jordan and Sam Fuller walked up to the stand that day, those warning signs were supposed to be up, right?
Yeah.
According to your policy, those warning signs were required to be up that day, right?
That's right.
So, ma'am, you admit that if those warning signs weren't up that day, that was a mistake, right?
would have been if they weren't. Yeah.
So let's talk about whether or not a mistake was made. Now, you
Sure.
told us that on July 4th, you actually spoke to Casey McCain in person, right?
I did. Yeah. He
You
told me
wanted
he
to-
thought, oh, I'm
go-
sorry.
Excuse me, ma'am. So you wanted to find out what happened, right? You wanted to investigate, right?
That's right. So I spoke to Casey and he told me he thought he put the warning sign up.
Ma'am, we'll get there, but you wanted to investigate, right?
Yes, I did.
So you asked Casey McCain, did you put up those warnings on July 3rd?
Yeah.
To be clear, Casey McCain said he wasn't sure, right?
He said, I think I put the warning sign up. I can't be sure, but I normally put them up every time. Yeah.
Can we display those warning signs for the jury? Casey McCain said he wasn't sure if he put up this warning in Exhibit 11.
He said he thought he did, but he couldn't be sure. Yeah.
Casey McCain said he could not be sure if he
Objection.
put up the warnings.
Asked and answered.
May I respond, Your Honor?
Yes.
Your Honor, we haven't asked this specific question. We're getting into these specific warnings, and we want to make it clear for the members of the jury that neither warning was up and that, in fact, no warnings were up. And so we can ask this additional question.
The objection is overruled. Proceed.
Casey McCain said he was not sure if he put up this warning in Exhibit 12, right?
That's right. He said he thought he did, but he couldn't be sure.
Ma'am, you'd agree with me. Casey McCain, he couldn't have put up those warning signs if he never physically had them in the first place, right?
Sure.
So let's take another look at that policy. Now, according to this policy, Casey McCain, he was supposed to get those warning signs that day from his supervisor, right?
That's right.
Ma'am, you never asked Casey McCain, did you get those warning signs from the supervisor?
No, I didn't.
You never asked the supervisor, did Casey McCain get these warning signs from you on July 3rd?
No.
Ma'am, as part of your investigation, you never even spoke to the supervisor who was working that day.
Nope. Didn't need to.
You didn't need to, ma'am?
No, I didn't.
Ms. Hudson, you can't tell the members of the jury the name of the supervisor who was working that day.
Not off the top of my head. I think I'd have to go back and check our records for that day.
But in your deposition for this case, you never mentioned the supervisor's name, right?
I don't think you asked me about it. No.
Ma'am, is it your testimony that the only reason that you didn't say that in your deposition is because I didn't ask you?
I think I said everything in my deposition that was part of my investigation, but I wasn't asked about the name of the supervisor.
So then, just to be clear, in this 12-page deposition, you never once mentioned that supervisor.
No, I didn't.
So let's talk about another way that your company could have warned the Fullers.
Sure.
Now, you'd agree with me, those protein bars, they came in packaging, right?
Yeah.
The packaging lists the ingredients.
Yes, it does.
The ingredients included peanut flour.
Yes, that's correct.
Could we put up that policy one more time? Thank you. Now, according to this policy, your employees are instructed to put the product packaging under the sample cart, right?
That's right.
It says put the ingredients list out of view, right?
Exactly. We want to make sure that the stand is nice and uncluttered.
So let's talk about that. The reason that it's your policy to not have those packaging or the ingredients list on the stand, it's not because of customer safety, is it?
I wouldn't agree with that. I would say there are a couple reasons we do it.
Well, like you just told us, ma'am, you don't want clutter, right?
True.
You think that would hurt sales, right, Ms. Hudson?
Right. And it would make it harder for the customer to see what they're about to eat.
So you instruct your employees to put the ingredients and the packaging under the stand.
Right. So the employees have it there if they need it.
Out of view. Right, Ms. Hudson?
That's right.
Thank you, Ms. Hudson. Your Honor, we have no further questions. Pass the witness.
Redirect.
Redirect, Your Honor.
Proceed.
Ms. Hudson, you were just asked a couple of questions about Casey's supervisor, and I'd like to follow up and ask, why didn't you contact Casey's supervisor about the warning signs?
Yeah, I didn't need to. So I spoke to Casey McCain and he told me, I think I put the warning sign up. I can't be sure, but I normally put the warning sign up every time. So technically that doesn't follow exactly what's written in our policy, but actually it's safer than what was written in our policy. Casey McCain didn't tell me, I didn't have, the supervisor hadn't given me the warning sign that day or anything like that. So I just didn't think I needed to speak to the supervisor.
Thank you. Nothing further. Your Honor, may this witness be excused?
You may. Who will be your next witness?
Yes, Your Honor. At this time, defense calls Dr. Robin Isbell.
Dr. Isbell, I remind you that you were previously sworn and you are still under oath. Counsel, you may proceed.
Thank you, Your Honor. Why don't you go ahead and introduce yourself to the jury?
Good afternoon. My name is Dr. Robin Isbell.
And what do you do for a living, Dr. Isbell?
I'm a pediatric allergist.
How did you become a pediatric allergist?
Well, I graduated from the University of Texas, my bachelor's in biology, and I went on to get my medical degree from Baylor College of Medicine. I did my 4 years of residency training in pediatrics and internal medicine.
For those of us who might not know, Dr. Isbell, what does a pediatric allergist do?
I treat children who have allergies.
What is treating children with allergies? What does that look like day to day?
Well, I have my own private practice. Working with kids every day is a little different, but generally I assess things like what they're allergic to, the severity of that allergy, and how to prevent contact with those allergens in the world.
Do you ever work with parents?
Yes. The majority of what I do actually is with parents on that last piece of how to protect children out in the world, since there's no cure for allergies.
How can parents protect their children when they're out in the world?
Well, I have very detailed conversations with them about different techniques that they can use, but what it comes down to is making sure that their child never has contact with what they're allergic to.
Dr. Isbell, have you ever worked with grocery stores?
Yes, I worked with the National Grocers Association. I worked for them as part of a group that brought together medical professionals and grocery store experts, and we best practices and guidelines for how stores should handle foods that contain allergens.
And Dr. Isbell, have you ever worked as an expert in a trial before?
No, I became a doctor to help children, so actually this is my first time doing this.
Are you being paid for your time today?
Yes.
And does that change your testimony today in any way?
No.
Turning to today's case, what were you asked to look at?
2 things. I was asked to compare Coslo's behavior with the standard best practices for grocery stores. And then I was asked to compare Jordan Fuller's behavior on the 3rd with best practices for a parent of a child with allergies.
Were you able to come to any conclusions?
Yes, I reached 2.
I'd like to talk about those in a moment, but first, what materials did you rely on in coming to those conclusions?
I reviewed the depositions of all the other witnesses in this case. I also reviewed photos of the sample stand, the protein bar samples, photos of the warning signs that the Coslo used, portions of federal law regarding packaging of food with allergens, and of course the NGA's best practices that I worked on.
Were these materials sufficient to come to a conclusion?
Yes.
What principles and methods did you apply to them?
Well, I relied on the best practices that we established for grocery stores at the NGA, and I performed a comparative analysis to Coslo's actions. I then did another comparative analysis with best practices for parents of children with allergies, and then compared that to Jordan Fuller's actions on July 3rd.
This comparative analysis is a standard in your field?
It is.
Did you apply it reliably today?
To these facts, yes.
At this time, Your Honor, defense offers Dr. Robin Isbell as an expert in pediatric allergies and grocery store food allergy warning.
Any objection?
Yes, Your Honor, we would object to that expert designation. The witness did not testify to any qualifications for her expertise in warnings.
Your Honor, if I may. Under 702, experts can be tendered if their expertise, this is knowledge, training, experience, might help the finder of fact, the jury, understand the issue just a little bit better. This expert spent years crafting the guidelines for grocery store allergy warnings. She's more than qualified to be tendered as an expert as such.
May I be heard, Your Honor? Your Honor, counsel misstates the testimony. We agree that we heard evidence that this witness has worked with grocery stores on their best practices and certain policies regarding food allergens, but we did not hear the word warning. This witness did not testify that she's ever helped to develop product warnings for allergies.
All right, I'm going to overrule the objection. Counsel, you may proceed.
Yes, Your Honor. And Dr. Isbell, what were those two conclusions you came to?
Sure. My first was that Coslo acted in accordance with best practices. My second is that Jordan Fuller did not take the care required of a parent of a child with allergies.
Okay, well, let's take those one at a time. First, I'd like to talk about Coslo Grocery. When it comes to allergy warnings, what is a grocery store's responsibility?
Basically, there just needs to be a way to check the ingredients.
What does that look like? How can a grocery store provide ingredients to customers?
Well, that's actually going to look different for packaged food and unpackaged foods.
What does it look like for packaged food?
Well, federal law requires that packaged food have labels on that packaging. And so parents can check that package.
Your Honor, sorry, Dr. Isbell, it looks like you broke up for a moment there. You were saying on packaged foods, there's a warning, and I'm afraid we lost you right after that.
I apologize. Am I back?
Yes.
For packaged food,
Your Honor, permission for this witness to keep her screen on, but dial in with her phone just to overcome the connectivity issues.
Proceed.
Thank you, Your Honor. Dr. Isbell, go ahead. I believe my co-counsel, Ms. Nichols, is sending you the dial-in information for this call. Go ahead and mute your computer, and you can call into the phone number you're receiving. And I believe she'll pop up in the waiting room when.
That's what I figured. I don't see her yet. I'll give her a few minutes.
Thank you, Your Honor. Wouldn't be a Zoom trial if something like this didn't happen at least once, you know,
We're in interesting times.
to say the least. Just making sure she hasn't reached out to me.
Oh, there she is.
Can you hear me?
It looks like there's a feedback loop. Can you mute your computer, please? Like, yeah. How about now?
That should be better.
Perfect. All right, Dr. Isbell, you were telling us how grocery stores can make ingredients available on packaged food.
Sure. So federal law requires that packaged food come with a label on it. So if they have that packaging available, customers, parents, they can check it.
So how do grocery stores make information available if there's no packaging, if it's unpackaged food?
Well, they need to have someone with the information there so the customer or the parent can ask. That's best accomplished by having an attendant at the stand, for example.
Now, you said earlier that Coslo didn't violate these best practices. How is that? What did Coslo do on July 3rd?
Well, they were sampling something that was out of its package. So what they did is they had an attendant there who had access to those ingredients. If someone was to ask, they could provide those.
All right, Dr. Isbell, we've talked about Coslo. Let's talk about Jordan Fuller. What is a parent's responsibility when they give their child who has allergies something to eat?
Well, the parent needs to find out what is that food before giving it to their child.
Can you say that first part again, Dr. Isbell? I'm afraid you cut out.
A parent needs to find out what's in their food before giving it to their child.
How can they do that?
Well, you always need to verify what's in it. So like I said, if it's packaged, they can check the label. But if it's unpackaged, it means asking questions.
And you said Jordan Fuller wasn't in compliance with this practice on July 3rd. Why not?
She never asked the attendant what was in those samples before she gave them to Sam.
Dr. Isbell, we've heard a lot about warning signs today. So I'd like to ask, does the absence of a warning sign mean that a parent shouldn't ask?
No. A parent's job is to get information. So the most a warning sign could do is remind them to get that information, but regardless, they need to ask to find out.
Thank you, Dr. Isbell. No further questions at this time, Your Honor. Defense passes the witness.
Cross-examination?
Yes, Your Honor. Good afternoon, Dr. Isbell.
Good afternoon.
You'd agree, as an expert, it's important to be impartial.
Yes.
To approach every case with an open mind.
Sure.
In this case, you were hired by the defendant.
Yes, I was.
A grocery store.
Yes.
You used to work for the National Grocers Association.
That's right.
They do lobbying work.
That's part of what they do, yes.
Doctor, in your own words, The National Grocers Association lobbies to make sure that grocery stores aren't overly burdened by things like health and safety regulations.
I think that's part of their lobbying effort, yes. I wasn't a part of that, though.
But that's how you, in your own words, would describe their lobbying efforts.
That was my understanding, yes.
You were on their payroll.
Yes, I worked there for 2 years.
In addition to being impartial, you'd also agree it's important to be thorough.
Yeah.
Important to look at all relevant information.
Of course.
You didn't visit the grocery store where Sam Fuller got sick.
No, I didn't need to.
You didn't get one of those protein bars and take a look at it for yourself.
No, it wasn't necessary.
You didn't speak to Sam Fuller's doctors?
No.
You didn't speak to the employee who set up the sample stand that day?
No, I didn't need to.
Doctor, I'm not asking you about what you think you needed to do. I'm asking you simply about what you did. It's true, you didn't talk to the employee who set up the sample stand that day.
That's true.
In fact, you didn't speak to anyone who was in the store that day.
No, I didn't.
As part of your work in this case, you didn't speak to anyone at all.
No.
Oh, wait, doctor, I'm sorry. You actually did speak to someone at the National Grocers Association, right?
No, I don't believe I did.
It's your testimony in court today that you didn't speak to someone at the National Grocers Association?
I believe they referred me to defense counsel, but I'm not sure if I was part of that conversation.
Doctor, I'm not asking about that referral. I'm asking, it's your testimony in court today. You didn't speak to someone at the National Grocers Association to prepare for your testimony today.
Oh, yes, I consulted with the NGA.
So that's a yes to my question. You spoke to someone at the National Grocers Association.
Yes, I apologize. I wasn't clear.
You also spoke to the defendant's lawyers.
I did.
You said that looking at the protein bar, visiting the store, that wasn't necessary because you looked at written materials, right?
Oh, yes, and I knew that the sample contained peanuts, so I didn't need to look at it.
Doctor, you spent a total of 2 hours reviewing materials for this case, right?
I did.
You spent 3.5 hours talking to the defendant's lawyers.
I did.
So now I want to talk about how serious a peanut allergy can be. You're a pediatric allergist, right?
I am.
So you know what peanut flour can do to a child with peanut allergies.
Yeah.
You know that if a child with a peanut allergy consumes peanuts, he can get sick.
Yes, that's why a parent needs to make sure that their child does not ingest peanuts.
Doctor, I'm not talking about parents right now. I'm talking about the symptoms of an allergic reaction. You'd agree that if a child with a peanut allergy eats peanuts, he can stop breathing.
That's true.
He can go into anaphylactic shock.
Yeah.
He can die. I'm sorry, doctor, I couldn't hear your last answer. Could you repeat it?
That's true.
So it's a yes. If a child with a peanut allergy eats peanut flour, he can die.
Yes, so I said yes.
Sam Fuller has a peanut allergy.
He does.
I'm sorry, did you say yes?
Yeah, Sam has a peanut allergy.
So let's talk about the defendant's allergy policies. You know that sometimes the defendant gives out food samples at the store.
Yes,
Sometimes those samples contain allergens.
that's true.
That means that some of those samples can be dangerous to children.
Yes, that's right.
Now, you testified on direct examination that parents, they're supposed to look at the packaging or the ingredients labels to know what's in food before they give it to their child, right?
Yes, and if they don't have one, they need to ask for it.
Doctor, I didn't ask you about that. I'm asking you about what you said parents are supposed to do, and you agree they're supposed to first check and look at the packaging, right?
Yes, with no exceptions.
You know it's the defendant's policy not to display packaging.
I do know that.
You know it's the defendant's policy not to display ingredients lists.
Not to display it, but they have it there if someone asks. Yes.
So that's a yes, it's the defendant's policy to instruct its employees, don't display the ingredients list.
Yep.
That's the defendant's policy even when the sample contains an allergen.
That's true.
Thank you, Dr. Isbell. I have nothing further. Pass the witness.
Any recheck?
Yes, Your Honor. Dr. Isbell, Ms. Golddiamond just asked you a number of questions about Coslo's policies. I'd just like to be clear, do any of Coslo's policies violate the best practices set down by the National Grocers Association?
No, they actually go above and beyond by putting a warning sign on stands when there's an allergen.
Thank you. No further questions, Your Honor. We just ask that this witness be excused.
You may be excused. All right, who's the defendant's next witness?
Excuse me, Your Honor. Oof. At this time, defense rests its case in chief, and we're ready to move on to closing arguments. Don't know what happened to me just then. Allergies, I guess.
Before we proceed to closing arguments, does anyone need a break?
Yes, Your Honor, the plaintiff would like a break, and we'd also like to know our time left remaining for closing.
Let's take just a very short break, 3 minutes, and while we're on the break, I'll get a time. Okay. When we come
Thank
back,
you, Your Honor.
we'll be in recess. Just 3 minutes. We're counting. Once my judges are back, can you just send me a little message or pop on real quick and let me know that you're here and ready for closings if you're a judge, please.
Mark Mann here, Judge.
Thank you.
William Paoli here, Your Honor.
David Deal here.
All right, thank you. right, we have all of our judges here, so we are ready. I'm going to see if Mr. Ruiz, would you give us our time check, please?
Yes, so plaintiff, you have 15 minutes and 57 seconds remaining. Defense, you have 22 minutes and 10 seconds remaining.
Thank you.
Thank you.
Plaintiff, would you like any time warnings in this part of your closing?
No, Your Honor, if I just may reserve the remaining time for rebuttal.
Of course. All right.
Thank you.
Okay, the court will recognize plaintiff's counsel for closing argument.
May I proceed?
You may.
Put the ingredients list where no one can see it. Put the packaging where no one can see it. And if the sample has an allergen, don't tell the customers. These are the instructions the defendant gave its employees. Now, all trial, defense has tried to call what happened the accident or the incident, but no, what happened to Sam Fuller is policy. The defendant's policy of hiding allergen information from their customers. That's why Sam Fuller got sick. That's why he almost died. Because the defendant hid the danger. As the plaintiff, we had the burden of proof, but it's not the criminal burden you may have seen before on TV. We didn't have to prove our case beyond a reasonable doubt. Instead, we had to show, just more likely than not, the defendant's negligence caused Sam Fuller's injuries. And we met that burden by proving 3 simple facts. The same facts Mr. Trevisani told you about in our opening statement. The defendant knew allergens are dangerous. They designed a policy to hide those dangers from their customers. They gave the Fuller family no warning that those samples contained peanut flour. Let's take these one at a time. Fact number 1, the defendant knew allergens are dangerous. We heard that from their own expert. If a child with a peanut allergy eats peanuts, he can get sick. He can go into anaphylactic shock. He can stop breathing, and he can die. But the defendant? They didn't need an expert to tell them that because they already knew. It's 2017. Dennis Comer walks into the defendant's store, tries a sample. He gets sick. He has an allergic reaction. To settle that lawsuit, the defendant promises, from now on, we will warn our customers about known allergens. Fact number 2. Despite that promise, the defendant designed a policy to hide allergy information from their customers. This is the defendant's employee manual. The very first thing the employee is supposed to do is check the ingredients list. And if they see an allergen, don't tell the customer. The defendant's not saying you're not required to tell the customer. They're saying you're not allowed to tell the customer. But it gets worse. You see, the employees, they're supposed to take that packaging, take that ingredients list, and hide them. That is information that could warn a person about allergens, that could warn a parent about allergens. But the defendant says, no, keep those out of view. At the beginning of the trial, defendant tried to pretend that these policies, they're about safety. We heard Parker Hudson, the defendant's CEO, they put those policies in place because we care about our customers. That's the same CEO who promised to follow the Food Labeling Act and then admitted on cross-examination that she'd never read it. Quote, Food Labeling Act? Never heard of it. That's the same CEO who signed a settlement agreement promising that they would put up warning signs, promising that they would follow that act, who then in cross-examination today said she wasn't sure. She didn't know whether she had to follow that contract. Today, Parker Hudson was forced to admit those policies, they're not about safety. She told you the real reason. She thinks ingredients lists make a sample cart look messy. She thinks she'd make less money. So this CEO admitted to you she puts profits over people, sales over safety, and clutter over caution. Fact number 3. The defendant gave the Fullers no warning. Those samples contained peanut flour. When Mr. Fuller walked into Coslo that day, the sample cart was supposed to look like this. Instead, it looked like this. And the defense, they denied this. They say, no, no, no. We always put the signs up. Of course they were up. So let's compare the testimony. We brought you someone who was there. They brought you someone who wasn't. We brought you someone who swore an oath and testified those warning signs were not up. They called someone who told you that someone else told them, I'm not sure. So we decided to probe deeper. You see, those warning signs, they don't come with every sample cart. The employee has to get them from the supervisor. So we asked CEO. Question. Did you ask Casey McCain if she got the warnings from her supervisor that day? Answer, no. Did you ask the supervisor if Casey McCain was given the warning signs that day? Answer, no, didn't need to. Question, do you even know the name of the supervisor that day? Answer, not off the top of my head. You never asked me about that before. Members of the jury, Casey McCain couldn't have put up those warning signs. She didn't have the signs. And Mr. Fuller couldn't have read the signs if there were no signs. And in the words of their own CEO, that was a mistake. This is the jury verdict form. This first question asks you whether the defendant's negligence caused Sam Fuller's injuries. Now, both parties agree. Sam Fuller was injured because of his peanut allergy, because of that allergic reaction. And we also know that those protein bars contained peanuts. So the only thing in dispute is whether the defendant was negligent. As the judge will explain, negligence means ordinary care. Would a person or a company practicing ordinary care have done what this defendant did? Would they promise to warn customers about dangerous allergens and then design a policy to hide that danger? Would they break their own rules and forget to put up the signs? Would they decide that avoiding clutter was more important than this 9-year-old boy? Members of the jury, not only is breaking your promises and breaking your rules negligent, it's not common sense. You can answer yes. The defendant's negligence caused Sam Fuller's injuries. So the next question is whether you will allow the defense to blame Mr. Fuller for his own son's injuries. They didn't tell you this in their opening statement. They have the burden of proof. To meet that burden, they called Dr. Robin Isbell. This is a doctor who spent more time talking to the defendant's lawyers than she spent reviewing material in this case. This is a doctor on the payroll of the grocery lobby that works to make sure grocery stores aren't burdened by things like health and safety. You can put a no next to Mr. Fuller's name. Now, in their opening statement, the defendant tried to tell you we were going to mislead you. We were going to deny Mr. Fuller did anything wrong. But you know that's not true because you heard the testimony of Mr. Fuller today. He came before you, he admitted he made a mistake. But that mistake was trusting this defendant. You see, Mr. Fuller, he had been shopping at Coslo for years. He knew that when those warning signs were up, the sample wasn't safe for Sam. And when the warning signs were down, the sample was safe. So when the defendant tries to point blame at Mr. Fuller, that blame comes right back to them. Three years ago, the defendant promised they would warn their customers about allergens. They promised that what happened to Dennis Comer would never happen again. But it did. And this time, it was a child. We ask you to find the defendant liable for Sam Fuller's injuries because they hid the danger. Thank you.
Court will recognize defense counsel for closing arguments. Ms. Lyon, would you like any time warnings or anything?
No, Your Honor, I should be all set. I just want to confirm the top of this board is visible and the bottom. Just gonna move this around, but we should be all set on time. Thank you, Your Honor. Top, bottom. Perfect. Court's indulgence. Ready to proceed, Your Honor.
Go ahead.
Only one person could have prevented this. Plaintiff's counsel just got up here and she told you a story about a big bad grocery store who didn't care about their customer safety. But that's not what the evidence today showed, members of the jury. Today, the evidence showed that Coslo, they cared about their customers. They put policies in place. And on July 3rd, they behaved reasonably. But Jordan Fuller on July 3rd, he didn't behave the way a reasonable parent should. Now today, plaintiff is alleging negligence. That means they have to prove 4 things to you by a preponderance of the evidence. Now, Ms. Gold Diamond just told you it's not as high as a criminal burden. It means more likely than not. But they need to prove each of those things by a preponderance of the evidence. And what's more, when you're looking at the evidence today, you can only consider credible evidence. That means that if you think a witness might have been twisting the truth, or someone was talking about a day when they were just distracted, that's not credible evidence. And that can't go to showing the plaintiff's burden. So I'd like to talk about those 4 things for Coslo to show how they weren't negligent on July 3rd. But then, as the judge will instruct you in just a moment, this case isn't just about Coslo. It's your job to determine who is in the best position to prevent the harm that happened to Sam Fuller on July 3rd. You have to weigh Coslo or Sam Fuller's father, Jordan Fuller. So I'm going to walk through those 4 elements for Coslo and then those 4 elements for Jordan Fuller to show how on July 3rd, Jordan Fuller is the only person who could have prevented this from happening. Now, those 4 elements are duty, breach, but-for cause, and harm. Now, before I go too far into this analysis, I'd like to talk to you about harm, because we don't dispute harm today. Sam Fuller was certainly harmed on July 3rd. He was harmed when he had that allergic reaction and had to go to the hospital that night in an ambulance. So I'm going to remove harm from the board. Now, plaintiff came before you and they said, Coslo, they had a duty. And we agree. Coslo has a responsibility to its customers. It's to make information available. You heard that today from Dr. Robin Isbell, a pediatric allergist who helped write the code for best practices for grocery stores when it comes to allergies. She told you, making that information available, that can look like having an attendant right there at that sample stand with a list of the ingredients. And Parker Hudson, the owner of Coslo, told you that they agree with that duty, that she has hundreds of customers coming into her store every day. Those customers have different preferences, sensitivities, and allergies. Too many questions to be answered by a sign or a scrap of information, and she wants to make sure everyone is taken care of. So an attendant is at that stand every day. Now, plaintiff tried to tell you that Coslo's responsibility was to have a warning sign out and to have packaging out, and that anything less was a violation. But members of the jury, think back, they couldn't point to a law or a code or anything at all that says that. So what they did instead is they called Dr. Kelly McKagan. Dr. Kelly McKagan, who's never worked on grocery store best practices on allergy warning signs before, never taught a class on them, published an article on them, has no experience in this field. They tried to tell you, well, he's experienced because he knows generally about warnings, but members of the jury, that's just not enough. Dr. McKagan came before you and talked a lot less about those warning signs than he spent time pointing the finger at Parker Hudson and calling her immoral. That's not credible evidence, members of the jury. Plaintiff didn't meet their burden for duty. So let's go to breach. You heard today from the plaintiff himself, Jordan Fuller, when he walked up to that sample stand, there was an attendant right there. And when he came back and finally asked that attendant, what's in this? That attendant reached under the sample stand and handed him an ingredients list. Coslo didn't breach their duty. They fulfilled it. Now, even if you believe plaintiff that Coslo's duty was to have a warning sign on that sample stand, members of the jury, we didn't hear credible evidence today that there was no warning sign. Now, plaintiff called Jordan Fuller, and he told you definitely there was no warning sign, but members of the jury, that's not credible evidence because we know he was distracted that day. It was the 3rd of July. He told you that store, it was really busy. His family was rushing around. He's trying to bring his 9-year-old son through this busy grocery store to try and get things for the next day's celebration. And we know he was distracted because he came across this sample. Dark brown on the outside, light brown on the inside. Plaintiff's own expert looked at this sample and said, yeah, that looks like it could contain peanuts. He saw this sample and he was so distracted, he didn't think to ask, does this have peanuts? Even though that's what he normally did. He told you today he normally asks. At sample stands at restaurants, he always asks, but he didn't on July 3rd. Mr. Fuller was so distracted that he picked this protein bar up, smelled it, ate it, and didn't notice it had peanuts in it. Even though his son, who'd never eaten peanuts in his life, took one bite at that bar and said, Dad, this has peanuts in it. Mr. Fuller was so distracted that his son had to insist before he would go back and ask that attendant, what's in this? Now again, Dr. McKagan tried to take the stand and he said something different on direct than he said on cross. So I'd like to talk about that now. On direct, Dr. McKagan said, well, I saw there was no evidence a sign was up, but members of the jury, that's not what he said on cross-examination. On cross-examination, I asked him, well, the attendant who worked that day believes he put a sign up. And the expert and plaintiff over and over again today have said, no, that attendant said, I don't know. But think about that, members of the jury. You can't take that out of context. We heard the full statement today from Parker Hudson. That statement, that full statement, don't let plaintiff distract you. That full statement was, I believe I put a warning sign up. I can't be positive, but I always put a warning sign up, even when there's no allergen. That's the full statement. Now, plaintiff tried to distract you with a supervisor. They said, well, there's a supervisor. And on direct examination, again, Dr. McKagan said, I saw no evidence that a supervisor gave him that sign. Dr. McKagan is an expert. He could have gone to Coslo, asked to talk to that supervisor. Could have asked to talk to Casey McCain, the kid working at the sample stand. Could have interviewed customers who were in Coslo on July 3rd. But plaintiff didn't seek that information out. And we have to ask ourselves, why? Why, when they bear the burden of proof, did they come into court today and talk a lot about people that they didn't call into court to question? The answer is simple. It's because they wouldn't have liked the answer. Plaintiff didn't prove breach. Next, they had to prove but for cause. But for cause, it's a legal term. It means that if not for Coslo's breach, Sam Fuller never would have suffered harm. To prove that today, plaintiff would have had to have shown you that if Coslo had followed the duty plaintiff set for them, put out a warning sign, that Jordan Fuller would have noticed it, recognized it, asked that attendant, are there peanuts in this? And not given a sample to his son. But members of the jury, plaintiff didn't enter sufficient evidence that Jordan Fuller would have noticed that sign because Jordan Fuller ignored every single common sense warning sign that day. You heard from plaintiff's own expert, Dr. McKagan. Warning signs, they're good, but they're not sufficient. What parents need is common sense. There were common sense warning signs present that day. Mr. Fuller just didn't notice them. So next, let's talk about Jordan Fuller. And I'd like to be very clear. We are not saying that Jordan Fuller is a bad father. We are certainly not saying that he does not love his son. All we're saying is that on July 3rd, he didn't behave the way a reasonable parent should. So first, duty. Jordan Fuller told you his responsibility on direct examination. He said, I never hand Sam something unless I know it doesn't have peanuts in it. That's his responsibility. Dr. Isbell told you the same. Parents' responsibility is to get information, it's to ask. That's Jordan Fuller's duty. There's no dispute here on that. So next, breach. Again, Jordan Fuller told you about his breach himself. He said, I never should have given him that sample without reading the ingredients first. He didn't ask. He breached his responsibility. Finally, but for cause. Now, the harm that we've talked about today that befell Sam Fuller on July 3rd wasn't just the harm of eating that sample. It was the harm of being brought home, slowly losing the ability to breathe in his own home, his lips turning blue, and after half an hour of exhibiting these symptoms, being rushed to the emergency room. Only Jordan Fuller could have prevented any of that harm. Jordan Fuller could have prevented that harm if he'd asked that attendant, what's in this? Does this contain peanuts? He could have prevented that harm if after his son had ingested peanuts for the first time in his life, he'd called his doctor, taken Sam Fuller to the emergency room. If any of those things had happened, then Sam Fuller wouldn't have been rushed to the emergency room later that night. We wouldn't be here today. What's more, members of the jury, is that Jordan Fuller knew this was his responsibility, and he knew he breached it. You heard today that Right after this incident, on July 4th, Jordan Fuller hired an attorney. 3 months later, in October, he posts this on Facebook. He writes, "He almost died because I gave him something to eat without knowing that there was peanut flour in it." You'll have this back in the deliberation room, members of the jury look at it. Because what he does next, he doesn't blame Coslo. He doesn't ask grocery stores to put up better warning signs. He calls out to parents. He says, "Friends, make sure you protect your kids." He knows that in this situation, he was the only person who could have prevented this. Now, we can understand how the guilt of causing your child such pain could bring you to a place where you want to find someone else to blame. But that blame does not rest with Coslo, because on July 3rd, they behaved reasonably. Don't let the plaintiff distract you about Coslo's policies around warning signs. They made warning signs mandatory, ingredients available, and all information accessible. They behaved reasonably on July 3rd. Find them not liable. Thank you.
All right. Before we proceed with rebuttal, Mr. Ruiz, how much time does plaintiff's counsel have left?
Plaintiff's counsel has 3 minutes and 10 seconds remaining.
Would you like a warning?
No, Your Honor, that won't be necessary.
Okay, you may proceed.
They told you over and over again. One person could have prevented this. Well, members of the jury, the defense is wrong. 3 people could have prevented this. Parker Hudson could have prevented this if he valued safety over money. The supervisor could have prevented this if he gave Casey McCain those warning signs. Casey McCain could have prevented this if he just put those warning signs up. 3 people could have prevented this, but instead they hid the danger. Find the defendant liable. Thank you.
Thank you. All right, at this time, I'm going to ask the judges to please complete your ballots and send those back in. And if everyone will just stay in the room until we make sure we've got all the ballots done and we can all add. So hang tight. Thanks. All right. Hello, everyone. While they are tallying these ballots, we're going to give you super brief comments. Usually it's supposed to be one thing we can say to you to help you improve for the next round, but this is it. So I'm going to ask all the judges to give, one very brief comment before we announce the winners. And so I'll start. My name is Nicole Mitchell. I'm a judge in the Eastern District of Texas, and I've been on the bench for about 8 years. And my comment to you is, man, you are all welcome in my court. Get your law licenses and get over here because you're so good. And you've also restored my faith in Zoom. So just phenomenal job, all of you. Great job. All right. Ms. LaFleur, I see you, so let's have you go next.
All right, and I will just tell you that I'm an adjunct at Marquette University Law School, and I'm a trial lawyer, and I would hire any one of you. You just did a phenomenal job. I'm so proud of you. I have no idea where any of you are from. I'm up here in Wisconsin. The only comment I would give is watch hand motions. A lot of you use your hands. Not all of you, but most of you use your hands, and that's kind of unusual to see in trial law. Because anything that distracts the jury from the word or what you want to show, you want to tap that down. You want the focus to be your word or an exhibit. So I just saw a lot of hand movement, and that's something I don't usually see very often. But other than that, I know that it's nerve-wracking and you can't see us. And one of the things you didn't get to have was being able to look at a jury and see our expressions. You had no way to read us. And in the real world, that's key. So I'll leave it at that.
Oh, Your Honor, you're muted.
The technology. David, are you on and done with your scoring? If so, jump on.
Yeah, I am. I don't know if you can see me put my video on here.
Yeah, let me see.
I think you have to put me on if you want to do that.
Okay, good. Hold on a second.
Okay.
You guys, I really have some skills, but
Can you let me, okay, start my video. Okay, there we go. Huh. Okay, anyway, let me just say I'm a trial attorney in Miami, Florida, and also an adjunct professor at the University of Miami Law School for over 30 years. And I've been involved in a lot of different trial aspects in the practice, including head of trial techniques of the American Bar Association's tort trial and insurance practice section, and had a pretty active practice for my whole career. The one thing I would say is think about your strategy a little bit more and try not to overcommit. Pretty much everybody at one point or another took on a little bit more of a burden than they needed to, and just focus on your case a little bit more, and and try not to say, well, they tricked you or they hid something. Focus on your theme and bring it home with your theme. I think that's more effective. And I thought with this case, even from the beginning, the theme of, for the defense, say, seeing the peanut filling in this protein bar was kind of a good one. Like, look, it was visible. How much more do you have to tell them? And on the plaintiff side, I think the theme is that they don't have to have giveaways with allergens, but if they're gonna do it safely. And these things are really serious and they know it, but they choose not to handle it in a reasonable manner because of their own business purposes. So whatever your overriding theme is, you just need to hammer it throughout, but don't take on too much and don't point the finger at the other side as how they're presenting it. But overall, I've been doing this a long time and have judged hundreds of mock trials over the years. And I would say this is one of the very best. You're excellent, clear speakers, good communicators, and those nuances are what you'll pick up in a real practice, but you should be commended for all the work you did to prepare. And it's very gratifying to see this high level of competition. So nice job.
all right. Good. Thank you, David. William, are you done scoring? And oh, good. Hi, Mark. Okay. You're next, Mark. Go ahead.
I just finished scoring. My name is Mark Mann, and I'm from East Texas. Practice in front of a lot of really good judges in the Eastern District, including Judge Mitchell. What I would say is it took me a little while to grade this because, I mean, gosh, you are all really, really good. And what I would say is this. I think every one of you, and I'm going to be general for each one of you, every one of you did a really good job of, to me, having a theme and sticking with it and emphasizing it and starting with a theme and ending with a theme. And that's what good trial lawyers do. And I try not to look at the facts of the case. I try to look at what your style and what do you do with what you have. And, you know, there are always some good facts and some bad facts for you. And I thought really and truthfully, each one of you obviously must have really worked on this hard because you used great wording, used great diction. And what I would say is I'm like everybody else. I think you're ready to go and try a lawsuit right now. And I look forward to seeing your names and lights at some time in the future. So those are my comments. I've got some specific things I wrote down, but I know y'all want to get on with it. So thanks very much for participating. It's great.
Thank you, Mark. All right, William. There he is.
Okay. Well, hi. Okay, I'm a civil trial lawyer. I do plaintiff work almost exclusively in Southern California, Newport Beach. Been practicing for about 30 years, and I can tell you, each of you did an outstanding job today. I'm somewhat jealous of Mark. I wish I had his accent.
And get rid of it.
Jurors tend to like that, but no. Again, I'd have to repeat pretty much everything that was said previous to my comments. Each of you did a wonderful job, and frankly, I think you're going to have a very good, successful career ahead of each of you as civil trial. That's just my preference. As far as speaking to a jury, I try never to give them an excuse to kind of discount what you have to say. It's not really a good idea to point the other finger at the other side. It's more important, I think, to work on your case. And again, as you've heard, you started out with a theme and you carried all the way through. And you know, I happen to like cross-examination because as you've all seen, you get to pretty much tell your story and you get them to say yes or no. It'd be a really good idea if at least the way I do is I usually start out yes or no. Isn't it true that, or isn't it true that, you know, then you say what you want to say and have them, you know, pretty much corner to either yes or no instead of going on and saying, of course, the opposing expert or opposing witness is always going to try to advocate for their side. So it kind of cuts them off. But no. Again, y'all did a wonderful job. And just like Mark, I had a difficult time trying to, in fact, I went back and forth trying to gauge who was the best, who was, you know, second and whatnot. I think you all should be commended for the good work that you've done and for your talents.
Thank you to our esteemed panel of judges. You are all in front of lawyers with just a ton of experience. So I hope those comments are well received because, and that you take them with the weight from which they come. So for these guys to tell you, you knocked it out of the park, should make you stand taller today. So good job. Okay, I'm gonna go check and see what's up with our ballots. Hang tight, nobody leave, okay? I'll be right back.
Okay, you guys, while the judge is gone, one more comment I can make for you. And that is, I actually, at least down here in Southern California, we have what's called temporary judges. So they used to be judge pro tems. So we actually fill in for some of the judges on the civil panel if they're on vacation, that sort of thing. I can tell you that by far, I have seen practicing attorneys who have done nowhere near as good a job as you the four of you did today. So again, you should be proud of yourselves.
Well, and I absolutely agree. And your ability to use the exhibits. I tried a 6-day case this summer on Zoom, and we hired somebody to help us with the exhibits because we're just not as techy as you are, because I'm not.
Are we, have all the judges had a chance to give their comments?
Yes, we were just chatting.
Judge Mitchell, you sure can.
If everybody in the room will turn your camera on so I can see everybody, since we're about to announce and I want to get a good look at everybody in the room, including the coaches. Let me just say, before we get to the announcement, I'm going to allow Judge Mitchell to do that part of it. Before we get to the announcement, I just wanted to say how impressive this final round was. I was watching the live streaming on the room, and I just want to commend both teams on doing a really, really excellent job. I also want to say thank you so much to our final round judges, a really, really amazing group of trial lawyers from all over the country. I especially want to say thank you to Judge Nicole Mitchell from the Eastern District of Texas, who came all the way to Waco to sit in the law school and watch this round for us and administer this round, and I thought did a fantastic job. And as one of our Baylor alums, we always appreciate the time they give us. Last, and then I promise we're going to finish this, I want to thank the National Board of Trial Advocacy so much. Their commitment to this tournament, their commitment to the students, their commitment to education and to what mock trial can be is so great. And I, on behalf of Baylor, but also on behalf of the larger community, just want to say thank you to the members that are in this room, and thank you to the organization for everything you've done for the Tournament of Champions and for these students on a year-by-year basis. And we appreciate it so much. So with that, I will turn it back over to Judge Mitchell for the things you all care about, which is the winner, the top speaker for this round, and also the winners of the 2020 MBTA Tournament Champions. So with that, Judge Mitchell.
Oh, this is so exciting. All right. Oh, I'm just so excited for all of you. Okay, I'll stop talking. Here we go. The top speaker for the championship round is Enrico Trevisani. Congratulations. Yay.
Thank you so much, Your Honor.
You're welcome.
And shout out to my co-counsel.
Yeah, good work to all of you. Okay, so the winner and champions of the 2020 MBTA Tournament of Champions is Team M, the UCLA School of Law. Good job, you guys. So proud of all of you. All right, that's it. So proud of you guys.
That's our whole show. So
Thank you so much.
congratulations, UCLA. Thanks everybody for coming out. And with that, we are done.
Thank you to Berkeley.
Congratulations.
You guys were
Thanks,
awesome.
Berkeley.
So much.
Bye-bye, everybody.
Oh, no wonder. Two great schools. All right. You guys take care.